The call is coming from inside the House. That would be the State House. Idaho's Attorney General is suing Idaho's Secretary of State to try to block the open primaries initiative on November's ballot. Idahoans for Open Primaries is also named in that lawsuit as a defendant for what Mr. Labrador claims they did to mislead Idaho voters in the petition process. But the head scratcher in all of this is pitting the two offices that are down the hall from each other, with one of them still allowed to represent the other. The state attorney general is supposed to defend and represent other state government officials, but if he is suing one of them, can he also defend them? How does that work? It's a question asked by Idaho Supreme Court as well, who are expecting to hear this case, and they wanted to get the AG's opinion or his explanation about this apparent conflict of interest. Joe Paris asked a former AG to do the same.
If you look at the legal documents without any context, it would appear that Attorney General Raul Labrador is suing himself. Labrador is suing the Secretary of State's office to keep a voter initiative off the ballot because of constitutional concerns he has. But the Attorney General also represents the Secretary of State. Is this a conflict of interest?
The fact that we have two different positions taken by separate teams of lawyers, both of whom carry the theoretical title of Attorney General, shows you that the system is working that the Attorney General has instituted.
Former Attorney General Dave Leroy says the AG's office laid out a great explanation in new court filings as to why the status quo here should be unchanged.
There are separate teams of lawyers. They are inconsistent in their positions, one representing the general state of Idaho position, one representing the specific wishes of the Secretary of State. And that shows me that there's not a conflict of interest under the rules of professional procedure. The Attorney General has carefully constructed two separate teams. The team representing the Secretary of State is not reporting back to the central office. Its electronic files are separate from those accessible by the Attorney General's office, and they are not communicating back and forth. Instead, the Secretary of State's team is doing exactly what the Secretary of State prefers in his approach to doing his duties.
So to answer the question here, is Labrador suing himself if he is in two different roles in this case?
The Attorney General's office is not suing itself. It is bringing an action on a state constitutional issue that involves mandating or directing duties by the court, if the Attorney General is correct, back to its client.
Some have pointed to a violation of legal ethics, a fair question. But Leroy points out an exception in this case.
There are special provisions that apply to government law firms, where those government law firms have statutory or regulatory duties that mandate them to do certain things for a broad range of clients. In that case, some of those conflict rules have exceptions, and that's what's in play here.
So, just how common is this?
This situation that has arisen is unusual, and the court correctly asked the Attorney General to make a good record of exactly why this is being done and how this is being done. And the Attorney General's reply clearly indicates that our separate teams of lawyers are doing separate interests so that there is no conflict.
At the end of the day, though, it will be up to the Idaho Supreme Court to decide if this is permissible. Brian, as of this point, they have not put down a filing to make a ruling or to verify that this is a good situation, so we'll keep an eye on that.
Okay, a couple questions for you. Did David Leroy have to deal with this while he was Attorney General?
Okay, so I asked him the same question, and long story short, he basically said that when he was the Attorney General, that government was a lot smaller, was a lot simpler. This is a situation that he's had to be a part of before, but Brian, in 2024, it's a lot different of a magnitude, but it is not totally uncommon or unheard of something like this to happen.
Two other instances come up. Idaho Department of Health and Welfare suing Raul Labrador, and Raul Labrador's office suing ITD. So what's the explanation there?
Right, so it can happen, and there are times where a court or his office will say, this is not an appropriate situation for us to basically be doing this at the same time. But in this case specifically, Brian, there is a situation in the sense where Labrador believes that he can keep his staff separate.
Okay.
And at the same time, I asked, what would the remedy be if the Supreme Court doesn't like this? They would have a third party, an independent law firm, come in to be the other side, but the AG would still oversee that. So it's very intricate, but we'll see what the court says.
In those other two cases, that is the case. They have an outside attorney representing Department of Health
Correct.
and Welfare and ITD.
And the ITD lawsuit we keep an eye on. Still no movement on that one. We're expecting some in August.
Okay, thanks, Joe.